Dear students, today we are going to discuss about bailment. The term bailment is derived from the French word bailer, which means to deliver. So, bailment, it is the transfer of goods from one party to another for some special purpose. According to section 148, bailment is defined as the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise or disposed of according to the direction of the person delivering them. So, in bailment, only the possession is being transferred from one person to another regarding a good, not the ownership of the good is being transferred. So, in bailment, there are two parties, and they are, the first party is bailer and the second party is bailee. Bailer is the person who is delivering the goods and bailee is the person to whom the goods are being delivered. For example, Mr. Ajay transfer his book to Mr. Rahul. So, this is the kind of bailment in which Mr. Ajay is the bailer who is delivering the goods and Mr. Rahul is the bailee who is receiving the goods or to whom the goods are being delivered. So, the next topic is essentials of a bailment. The first essential of the bailment is delivery of possession. In bailment, we are delivering only the possession right from the bailer to the bailee and not the ownership. So, it is the first essential of bailment. The second one is contract. According to bailment, it is an agreement between the bailer and the bailee to transfer good for some special purpose. It can be of express agreement or can be of implied agreement. And the third is delivery of goods for some special purpose. We have said that bailment means transfer of goods from the bailer to the bailee and it should be for some special purpose. If the goods are being delivered from one person to another by mistake, it does not come under bailment. So, the goods are to be transferred from the bailer to the bailee for accomplishing some special purpose. And the fourth essential is return of goods. The goods are to be returned by the bailee after the expiry of the period or after accomplishing the special purpose, and it is the duty of the bailer to receive back the goods from the bailee. And the last essential is regarding movable goods. This essential says that the subject matter of the bailment must be movable goods. We cannot bail the goods which are immovable in nature. So, these are the basic essentials of bailment, that is delivery of possession, contract, delivery of goods for some special purpose, and the goods are to be returned by the bailee to the bailer after the expiry period or after accomplishing the special purpose. And the last one is the goods are the subject matter of bailment. Now we are moving on to kinds of bailment. The bailment can be classified into two, gratuitous bailment and non-gratuitous bailment. So gratuitous bailment is defined as when some consideration passes between, when no consideration passes between bailer and bailee, it is termed as gratuitous bailment, and when some consideration passes between bailer and bailee, it is termed as non-gratuitous bailment. So in gratuitous bailment, no consideration or no payment, and in non-gratuitous bailments there is some consideration between bailer and bailee. For example, if Mr. Rahul transfer his car to Mr. Ajay on rent, it is a type of gratuitous bailment. And if there is no rent and if he is transferring just as a friend only, it is a type of gratuitous bailment. So gratuitous bailment, it is the bailment in which there is no consideration passes between bailer and bailee, and non-gratuitous bailment, it is a kind of bailment where there is some consideration passes between bailer and bailee. Next topic is regarding the duties of a bailer. We have said that who is a bailer? Bailer is the person who is delivering the goods to someone. So he has some duties to be performed. And first, his duty is to disclose the non-fault regarding the goods which is going to transfer to his bailee. So there is a distinction between gratuitous bailment and non-gratuitous bailment regarding the responsibility of disclosing the facts. In case of gratuitous bailment, the bailer has to disclose the facts which he is aware of. And in case of non-gratuitous bailment, he should make sure that there is no fault in the goods which he is transferring, and also he should ensure that it is safe enough to transfer from the bailer to the bailee. So the first duty of a bailer is to disclose the non-faults, and there is a distinction between gratuitous bailment and non-gratuitous bailment regarding the responsibility. What is the distinction? Regarding gratuitous bailment, he has to disclose the faults which he is known or which he is aware of, and regarding non-gratuitous bailment, he has to make sure that there is no fault in the goods which he is transferring. The second duty of a bailer is to bear the extraordinary expenses. That is, the bailer must reimburse the bailee for the extraordinary expenses which is incurred to the bailee, and as it is not a default from the bailee. So it is the duty of the bailer to reimburse the extraordinary expenses which happens to the bailee while using the goods. The third duty of a bailer is to indemnify the bailee. When the title of the goods or when the title of the bailer regarding the goods is defective and some loss has been occurred to the bailee while using the goods, it is the duty of the bailer to indemnify the bailee the loss occurred to him. The next duty of the bailer is to indemnify the bailee in case of premature termination. So a gratuitous bailment, a bailer can terminate the bailment at any time he wants, even if it is entered into for some special purpose or for a specific time. However, in case of premature termination of bailment, it is the duty of the bailer to reimburse the amount of loss which has occurred or which has incurred to the bailee. So it is the duty of the bailer to indemnify the bailee in case of premature termination or in case of any loss occurred to the bailee due to the premature termination of bailment. The last duty of the bailer is to receive back the goods. It is the duty of the bailer to receive back the goods which are being returned by the bailee after the expiry period or after accomplishing the special purpose. So, these are the duties of a bailer. Next is the rights of a bailer. So, the first right of a bailer is the enforcement of bailee's duties. It is the right of a bailer to check whether the bailee is performing his duties or not. Bailee's duties include whether he is taking care of the goods or whether he is mixing his personal goods with the goods he is bailed or whether he is using the goods in an unauthorized way or not. So, it is the right of a bailer to check whether the bailee is performing his duties properly or not. The second right of a bailer is termination of bailment. If there is any inconsistent or unauthorized use of bailed goods by the bailee, the bailer has the right to terminate the bailment. So, if the bailer finds any type of inconsistent or unauthorized use of the goods, it is the right of a bailer to terminate the contract of bailment with the bailee. The third right of a bailer is to get back the goods which is lent gratuitously. So, if some goods are transferred by the bailer to the bailee gratuitously, the bailer can ask for the goods whenever he wants, even though it is given for some purpose or for a specific time. And the last right of a bailer is right to file suit against any wrongdoer. If a third party does something which deprives the bailee from performing his duties or deprives him from using the bail goods, the bailer can file a suit against the wrongdoer and claim for compensation from him. And also, if the bailer finds that a third party is using the goods in an inconsistent or unauthorized manner, then also the bailer can file a case against the wrongdoer and also claim compensation from him. So, in today's class we have discussed what is bailment, definition of bailment, then what are the essentials of a bailment, then we move on to kinds of bailment. There are two kinds of bailment, gratuitous bailment and non-gratuitous bailment, and also we have looked duties of a bailer and also the rights of a bailer. I hope all you have understood. Thank you.